past 2 years, I've been working on a writ of habeas corpus involving the interpretation of complex DNA mixture samples. And because I think it's a matter of public concern, I want to discuss it here on my video blog. I'm going to try to explain what's going on. I'm not going to talk about the case specifically that I'm working on because it's still open and I don't want to jeopardize anything in that regard, but I do want to talk about sort of the general concepts in the case and how they might affect the public. So the first thing to know is that the whole case involves something called the Swig-Dam Interpretation Guidelines, which fundamentally changed in January of 2010. Swig-Dam is the scientific working group for DNA analysis methods. They're a group commissioned by the Federal Bureau of Investigation to promulgate guidelines in DNA science. In 2010, they changed their guidelines to sort of do away with an outdated protocol. Recent science in DNA interpretation found that these guidelines prior to 2010, the protocols that were being used by labs all over the country were outdated. One, they had a very real potential to lead to false inclusions, and two, in any inclusions that were made, they had a very real and practical ability to overstate something called the CPI statistic. The CPI statistic is the statistic that's given to a jury and sort of opined on by the expert that sort of associates mathematically the compelling nature of the inclusion. And the CPI statistic asks this fundamental question: what are the odds that a person chosen at random would be an inclusion in the mixture sample? So for example, if the CPI statistic was 1 out of 450, then that would mean if you chose 450 people out of the general public, one of them at random would match the mixture profile. And so around that time, 2010 and 2009 and then thereafter, it was found that the way crime labs were interpreting these methods was overstating that statistic. And of course, that's a big problem in forensic science. So in 2010, the new guidelines came out under Swig-Dam. And when the new guidelines came out, that fundamentally changed the opinions of forensic scientists across the nation. So for example, a person who was included as a contributor in a complex DNA mixture sample and was given a CPI statistic, again, of say 1 out of 450, now it's possible that that person is no longer considered an inclusion. In other words, it's inconclusive. And also, there's no statistical calculation that could be made with regard to that person or with regard to anybody because the sample just isn't appropriate for that kind of analysis. And so you can see that this is a problem in the forensic community and the criminal justice community. How does that affect people in California who are serving prison sentences right now who might have been convicted based on evidence that has now been undermined by the Swig-Dam 2010 guidelines? Well, there is a new law that went into effect in January of 2015, and basically what that law says is that state laws can challenge their convictions if their convictions were based on some kind of false evidence, and that one of the things that counts as false evidence is opinions of experts that have either been repudiated by the expert who originally provided the opinion at a hearing or trial, or that have been undermined by later scientific research or technical advances. So basically what that means is that if you're a California state prisoner and you are convicted sometime prior to 2011 and DNA evidence was used against you, and that DNA evidence was complex mixture interpretation evidence, you need to get your case reviewed because you might have a legal remedy. There will be more on this issue, and I'll try and break it down more. If you have any questions, I'm happy to take those as well. Thanks.